Hello and welcome back to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan, Member Supreme Court Bar Association. Today's video addresses a burning legal question. Can BJP MP Dr. Nishikant Dubey be punished for his public statements against the Supreme Court and the Chief Justice of India under Article 129 of the Constitution and the Contempt of Courts Act, 1971? Let's explore the law, the precedent, and the controversy. Part 1. What did Dr. Nishikant Dubey say? Recently, BJP MP Dr. Nishikant Dubey made multiple public statements and tweets criticizing the judiciary, including: if the Supreme Court is to make laws, then Parliament should be shut down. The Supreme Court is responsible for inciting religious wars. Chief Justice Sanjeev Khanna is responsible for all the civil wars in the country. You will dictate Parliament? How can you give directions to the appointing authority? These remarks have triggered widespread outrage and led to calls for criminal contempt proceedings, with formal representations sent to the Attorney General of India seeking permission to initiate legal action. Part 2. What does the law say? Under Article 129 of the Constitution, the Supreme Court is a court of record and has the power to punish for contempt of itself. The Contempt of Courts Act, 1971, defines criminal contempt as scandalizing or lowering the authority of the court, interfering with judicial proceedings, or obstructing the administration of justice. So, do Dr. Dubey's remarks amount to criminal contempt? To answer this, let us recall a significant and recent precedent. Part 3. The Prashant Bhushan contempt case, 2020. In 2020, the Supreme Court took suo motu cognizance of two tweets by senior advocate Prashant Bhushan. One tweet criticized the judiciary under several Chief Justices of India. Another featured a photo of the then CJI riding a Harley-Davidson motorcycle, questioning the functioning of the judiciary during the COVID-19 lockdown. Key observations by the Supreme Court. Criticism of the judiciary must not cross the line into scandalizing the court. The court emphasized that freedom of speech is not absolute, and the reputation of the judiciary is a matter of public interest. Bhushan was held guilty of criminal contempt. However, considering his stature and contributions, the court imposed only a symbolic fine of ₹1. This judgment sets a clear precedent. Public statements that attack or malign the judiciary may amount to criminal contempt, irrespective of the speaker's status or intent. New developments. The Supreme Court has not yet directed the Solicitor General to initiate contempt proceedings against Dr. Dubey. However, the court has clarified that its prior permission is not necessary to file a contempt petition. According to Section 15(1)(b) of the Contempt of Courts Act, 1971, private individuals must obtain the consent of the Attorney General to file such a petition. The matter was mentioned before a bench comprising Justice B.R. Gavai and Justice Augustine George Massey. The appearing lawyer informed the court that the Attorney General had not yet responded to a request for consent. The lawyer also highlighted that Dr. Dubey's remarks had gone viral and accused the Chief Justice of all civil wars in the country. Despite the seriousness of the allegation, no response had been received from the Attorney General's office. Justice Gavai briefly remarked, "List it next week," thereby scheduling the matter for hearing. Legal news platform Bar and Bench has reported that the Supreme Court will hear the plea-seeking contempt proceedings against Dr. Nishikant Dubey next week. On Tuesday, 22 April 2025, the Supreme Court directed that the matter be listed for hearing in the coming week. If the court finds merit in the petition, it may issue a notice to Dr. Dubey and initiate contempt proceedings. This would be a significant development, as contempt actions against a sitting member of Parliament are rare and carry serious political as well as legal consequences. The question now arises, will Dr. Dubey be punished? Given the gravity of Dr. Dubey's remarks, particularly accusing the Chief Justice of being responsible for civil wars and suggesting that the Supreme Court should be shut down, these statements may erode public confidence in the judiciary and may amount to scandalizing the authority of the Supreme Court. Therefore, If the Supreme Court maintains the same consistency as seen in previous cases, Dr. Dubey may indeed be punished under Article 129 of the Constitution and the Contempt of Courts Act, 1971. This case also raises vital concerns about the balance between freedom of speech and the dignity of the judiciary. This is not merely a matter of political confrontation, it questions whether constitutional institutions can be publicly defamed without consequence. The independence, credibility, and authority of the judiciary are at stake. As legal professionals, lawmakers, and responsible citizens, it is our collective duty to ensure that criticism stays within the framework of the Constitution and does not become a weapon to weaken our democratic institutions. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.